In this video, we're going to talk about the concept of willful infringement. Willful infringement talks about when one is aware of someone's patent rights and they proceed to recklessly go ahead and infringe those patent rights. If someone is found to be a willful infringer, a court can triple the damages award against them. So obviously, being found to willfully infringe someone else's patent can result in a very large verdict against you. Now, it used to be the case that under the law, once you were aware of a competitor's patent that potentially covered your activities, you, generally speaking, had an affirmative duty to go out and get what's called an opinion of counsel. An opinion of counsel refers to a written document from a trained patent attorney that analyzes whether your contemplated product or service would infringe a valid claim of a patent that that opinion was addressing. So in other words, if you were planning to launch your new product, you were aware of a competitor that had the patent that potentially covered your product, you would go to a patent attorney and say you wanted a written opinion of counsel, and that patent attorney would write a document either laying out your best arguments why your product would not meet each and every element of all the claims of that other patent, or that the claims you're concerned about were invalid in light of prior art, thus giving you a good faith state of mind why your product or service would not infringe someone else's patent rights. Now, the law has changed. There's a 2007 case from the Federal Circuit, and under the American Invents Act, which the provisions went into effect March 16, 2013, it's much harder for one to be found to be a willful infringer. So this makes things a little bit easier for startups. Because for startups to go and pay for an opinion of counsel whenever you become aware of third parties' patent rights, it's cost prohibitive. An opinion of counsel can often cost more than $20,000 just for one patent, and sometimes there can be more than one patent you're concerned about. Now, it also used to be the case that the threat of being found to be a willful infringer was so great that technology companies would avoid even looking at their competitors' patents. They didn't want to become aware of those patent rights such that they had an affirmative duty to go out and pay for an opinion of counsel. They would basically stay willfully blind to third-party patent rights. But for startups, this may not make sense. Number one, as I mentioned, the law has changed, so it's harder to be found to be a willful infringer, and the need to go out and get an opinion of counsel from a trained patent attorney is not as great as it used to be. Startups tend to take a more practical view that if you go out and look at your competitors' patents, it increases the chance that you could actually design your product or service in a way that it does not infringe those third-party patent rights. You can design around competitors' patents. And the benefit from being able to design around those competitors' patents far outweighs the risk of being found to be a willful infringer. You need to keep in mind that in order to be found to be a willful infringer and have a court triple the damages against you, you first have to be sued by the third party. You then have to proceed all the way through litigation and lose that case and have a damages verdict handed down against you, and then the court would have to triple that damages verdict because you're a willful infringer. For most startup companies that lack the resources to engage in patent litigation, you're never going to get that far down the road. It's usually a very bad thing if you're sued in the first place, and you usually won't even make it to the point in time where you've lost the case because you will have run out of cash. So, again, for most startup companies and entrepreneurs, the benefit from going out and looking at competitors' patents and understanding the patent landscape in your field far outweighs the minimum risk that you'd found to be a willful infringer and therefore suffer a larger verdict against you. Also keep in mind that even though the threat of being found to be a willful infringer is small, you want to be careful about what you put in writing about third parties' patents, because something that's in writing can be taken out of context down the road and cause you problems in negotiations, litigation, things like that. And that's a general overview of the law of willful infringement.